as a dependent, as a child, as a family member, who is a close family member and a dependent of a testator, you can challenge his will if he doesn't make provisions for you.
Because I was just going to ask you, Olamide, if someone can decide to will a property or all his properties to one person in the family without anybody saying you can't do that.
You can challenge it.
Yeah.
The court has discretion to redistribute the property.
But that's the person's. Yes. But that's the person's last wish. The person might have a good reason, even maybe stipulate it in the will.
Unfortunately, not many people know of that provision, but it is applicable. If you feel that during his lifetime, he was catering to you. So take, for instance, if you were if a testator had a nephew or nieces that he was catering to who were in university, maybe age 18, 19, and couldn't, of course, they were still in uni, and he was solely responsible for their maintenance, education, and all of that. And he dies suddenly, but with a will, and he doesn't make any provision for them. They can challenge it. You have a child who you put in England, who is in the university, who is not self-sufficient, and the man dies, and you don't make any provision for that child. You can challenge it. You, as a spouse, your husband just makes provision for his concubine and you don't have anything from, you can challenge it. So I don't think many people know, but so that is why when you're writing your will, it's important that in as much as you can write it, you have the testamentarial freedom. It is imperative that your legal counsel should advise you of all these restrictions so that it minimizes the risk of being challenged in court and spending years and years in court.